Good morning. Are you Leonard Guillory? And Mr. Guillory, in cause number 2240982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
Yeah, it was with a vehicle. That's what, at least what the administrative hearing says, but
I don't know that it was with a vehicle.
I haven't seen anything about it evading.
I think
It was only the.
My recollection was that it was evading on foot. I'm happy to explore it.
that's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. In the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly was
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
Oh, ma'am, Judge, is this argument?
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Guillory had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case with the ag assault, understandably, it will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for the complainant witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than $200,000, a bond that high. A lot of bonds from the courts It's all, a lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or they've been going to court on that, my understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's, obviously that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that.
Yeah.
So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause it's not public.
Gotcha.
I'm sorry, Jen.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is. Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on, that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. based on all of the allegations in the motion as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find based on...
And that's what makes this hearing so powerful. The judge showed compassion, but she also made the consequences impossible to ignore. Now it's up to him to prove that this second chance wasn't wasted. What do you think? Did the judge make the right call? Let me know below.
All of that information under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know. We'll get someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April, well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well.
Yeah,
Okay.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. Let's see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, no.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
No, no.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738 to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
Jamaysha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. Good morning. You're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count 1 in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count one that he pled to was the count where he was arrested for a burglary of a habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
And, go
just,
ahead.
so you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review, have corrected them in 7 and 8, I believe.
Okay, so
That's
there
why
was a
it's
first amended.
yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those please don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count one alleges that you were arrested. Okay, so did you want to,
Abandon 1 and 2, Judge, and show that they're correctly reflected in the First Amendment 7 and 8 committed.
all right,
That's
so,
what you didn't like the arrested for last time?
well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay, so 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
True or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true? Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025, you tested positive for alcohol. And is that true or not true?
That's true.
Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true?
That's true.
And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true?
That's true.
Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the rich street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would.
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substance Act.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, ma'am.
And because they're actually true.
Yes, ma'am.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay.
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report of Mr. Kimler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I could do that, but she has not been cooperative with me.
Okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove that up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but so go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we order him to ISF, I will file a dismissal today so that doesn't hold him up. If that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
Cognitive track or substance abuse, Your Honor?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking, moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you, or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
Ronia.
I'll represent the court.
Ronia Parkerson. I'm asking him. I'm asking
I
him.
understand that she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
He is no.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you
She's
want to have her
outside.
brought in?
Oh, we can just have her brought in.
Would you please call the name Aronia Parkerson?
So, drug substance abuse, contract information.
If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamel?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamel?
Yes, ma'am.
Your may the record reflect that the witness has identified the defendant in this hearing.
The record will so reflect.
Judge, on Saturday, April 26th of this year, at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made.
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but the first time they were called, he was trespassed. And the officers explained to me that if I called them back, that the trespass warrant would be voided. I was okay with that because I knew I was gonna call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through a lot. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also in my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed, and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby.
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point, I started recording a video just to get him away once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay. And is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lavelle?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
And has he pressured you or made you any promises or coerced you in any way?
No, ma'am. I did this of my own free will.
And do you understand that if those charges are dismissed, they're not going to be refiled?
Yes, ma'am.
And that you are taking your safety with Mr. Lamel into your own hands?
Yes, ma'am.
And are you asking the court to follow any agreement that she decides to make with respect to sending him to some substance abuse treatment, so that hopefully when he gets out, your relationship can be more productive
Yes, ma'am.
and he can help you raise those babies?
Yes, ma'am.
Thank you. Pass it on.
I have no questions.
Thank you, ma'am. You can go have a seat. Okay. Not a good way to handle that situation, was it?
No,
When you hear it out loud, how does that make you feel when you hear out loud what you did that night?
a little disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
Right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same. I'm sorry?
I'm sorry. I
Yeah, no, you're not going to get all of this again. Does that make sense? You're likely going to be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So Probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations, okay? All right, good luck to you, sir.
And just like that, the courtroom reaches its final outcome. One defendant leaves without bond, another faces even tougher conditions, and one receives a final opportunity instead of prison. Every hearing ended differently, but they all carried the same message: second chances exist, but they don't last forever.